Allegedly. Everything's allegedly.
Oh, the
Calling
witness,
from the jail.
right.
Okay,
He picked up
everything's alleged.
right.
So that caused a second case, and in my opinion, a second PCC. So we want a preliminary examination for everything. The people have advised me that they will go forward with or without the witness. I explained all this to my client. He exploded. So
What?
exploded. Well, so I didn't know what I was doing.
Okay.
So, and not fighting for him. And that bothers me more. They can tell me I don't know what I'm doing. That annoys me. But when they say I'm not fighting for them, that goes to my core, since I come from a fighting family. And I fight for everybody.
Oh, you do.
No, that just is making me talk to you. I am going to fight, but I got to fight within the rules. And I feel I know them a little bit better.
Counsel, I'm just trying to figure out, he told you weren't fighting for him?
Oh, for sure. And a lot more too.
Okay.
Yes, that's why I want to just express myself.
No, yeah, that's fine. You know, it's kind of funny to me when defendants that they're in custody, they find themselves in more trouble because you were trying to set this. You were fighting for them. You were fighting at me a little bit with this thing, and then has the nerve to say to you, "You're not fighting for him." When the reality is, at least allegedly, he's doing the stupid thing that's making your job harder. So that's fine. That's the way he wants to look at it. And the other thing is, and it just amazes me with some defendants, they come up here, they complain about their attorney, and they don't even realize the jewel that they may have representing them, and also don't realize, that fight is... It wasn't quite anything you did. It's just in your blood.
Thank you.
It is your heritage.
I was carrying.
He doesn't understand that. He doesn't understand that you got to play by certain rules. He just wants to do it his way. So if he wants to do it his way, we'll do it his way. It's not going to turn out real well. So what do you wish for me to do, Ms. Ford?
I'm asking that we set this for a preliminary examination, that you hear from the prosecutor and my client. Understand that I am really putting forth a top effort, and along with fighting, I actually have skill. So I hope that he understands that.
Well, he also needs to understand that there's going to be a motion for them to proceed by forfeiture, I'm presuming, and that's going to make your case whatever it is. And I know your counsel will be ready to go forward. I know the prosecutor will be ready to go forward. But you understand that, Mr. Abs?
I understand everything.
Okay. Then let's
in case she does not have discovery.
correct. So
Just to the courts.
He has discovery on the first one.
on the first case, but not on the second case.
Correct.
There were phone calls. So how many phone calls are we talking about? Because he's going to have to see all of that, go through it all. So I want to make sure he has time so we're not hearing a complaint about that.
As long as possible, within reason.
Yes.
It has to be reasonable.
You didn't have to explain that when I asked you what they going on without the victim.
Oh, excuse me. Let me put this on the record. I did explain that I guess it's hard to understand the various exceptions to hearsay and how in certain instances they can go forward without the victim. I was trying to explain, and then the people gave me a case I haven't read, but I was trying to give him the site People versus Only 327 Mishap 319. Would the court please explain to my clients certain instances where they can go forward without the victim? Excited under its mental state.
There are exceptions to the hearsay rule. Given that this is a domestic violence case, there's a statute which would apply, which would allow them to proceed with police testimony. Also, and I don't know if this is the people's intent, they would file a motion to proceed by forfeiture, meaning that because of, it's a simple way of putting this, because of your wrongdoing, the alleged victim is not present. So the people would, in that instance, not be punished by what is your behavior, or at least allegedly your behavior, Mr. Abs. and so would be allowed to proceed. That's kind of a nutshell version. I mean, there are a little bit more technicalities to it, but I think that
One of the technicalities would be MCL 768.27C, and as I indicated, that case, People versus Only 327, Mishap 319, and the various exceptions to the hearsay rule. That might be excited utterance, present sense impression, mental state of mind.
yeah, I mean, it's all
And
all
other.
of that kind of thing.
Do I
They
got a
will-
right to cross-examine my accuser?
You know what? Here's the thing, sir. That, if you're talking about the right to confrontation, there's a statute particularly on point where that may be forfeited because of what is alleged to be your behavior. That was the last thing that I brought up.
What do you mean by that, sir?
I am not here to give a law school class, although I could. I'm not, I know, but I'm just saying that is very technical. That's why you have an attorney.
But I couldn't explain it anymore, and that's why I brought it up.
You just broke down law school for her. How am I different?
I didn't break down law school.
Okay,
for
I'll
her.
tell you-
She asked the
We
question.
have told you.
I asked
All right,
the
I'm
question.
done. I'm going to set it for exam.
I'm going to go to the jail today, so I will,
So
I'll
what's
tell
that?
you.
Preliminary examination in this matter, because
Yes.
people may have a motion. I'll set it for September 17th, 2020.
Okay, just one moment, please. Just, yeah, don't turn your back on it, please.
September 17th, 2024,
Yeah, but he might be if you like.
9 a.m. That's before me.
Thank you.
When?
September 17th at 9 a.m. Oh, wait a minute, excuse
Why
me.
so long?
Uh,
That's 3 weeks.
yeah, September 17th, I can do that, but not the 8th, because that's the judge's calendar. And I'm a deferred professional. There are some parameters, and you are not
Speedy day.
being, oh, that's the new thing in the jail I'm learning, that I'm being.
And I would anticipate the people's motion, so we'll try to
Speedy
hear
trial
that.
is the new
before the-
buzzword in this world, and everything is a violation of that.
Of what?
Speedy trial. That is the new buzzword in the.
That has,
Just, can I ask a question? What is about what's going on in the jail? Speedy, none of this
You
particular
just
about
said
my
speedy.
case.
You just said you had a right to
Like
speedy
this,
trial.
I didn't say, I asked why so long. I didn't say nothing
It's
about
not a
no speedy
violation
trial.
of speedy
I asked
trial.
why so long. I didn't say nothing about no speedy trial. Like, Judge Sim, this is where we having a conflict at, sir. I'm asking about my case, and it's everything other than the case. I don't want to talk about nothing but this case. All
okay,
this
but Mr. Epps,
speedy
hold on,
trial-
slow down. You have two things now which have,
And I
hold on.
This is the moment the judge basically says what everyone in the courtroom is thinking. The defense attorney is clearly fighting hard for her client, and the client has the nerve to accuse her of not fighting for him. The judge jumps in with a little courtroom reality check, pointing out that the defendant's own alleged actions are making things worse. Awkward? Yes. Honest? Absolutely.
Hold on. You asked me a question, but you're operating off of a premise that isn't going to work. So here's the thing. You had the one case come up. We then had the hearing. There were allegations made, and this is where the complication comes in. There are allegations that are then made that there is phone contact and other communication. I don't know for sure. The allegations have been made. There's evidence of the phone calls. So that's where we are. What the problem then that happens is that leads to additional charges, which then not only is there now this additional felony, that clearly will have an impact upon what the first case that you came. That's what counsel's trying to get through. She's got to get that information. That then leads to other things.
Okay, I understand that. She's not explaining that, sir. That was simple things to understand.
I accept.
Okay.
We're good.
I can't get in between every counsel and attorney and defendant.
Thank you for
And
that.
I'm not trying to do that. I'm just trying to explain the process, and I've got to, Mr. F, I've got to be fair to both sides. So I got to have it worked out. You would have had an exam before now, had this not come up.
That's understood.
Okay? So that's the reason for the stretch out in time.
Okay.
Also, the other thing, so that you just understand, it's not anybody trying to delay anything. because of the allegations that come with that and sort of this complicated thing, I won't say it's complicated, but it's a thing where they're going to proceed, presumably, and I don't know if they know this for sure, without the witness. Your counsel has to try to do some things. I've got to give her time to do that for your protection.
Okay.
So it's not trying to stretch anything out. I'm just trying to make sure everybody has an opportunity to do what it is they need to do. It's really as simple as that.
Thank you.
Can I say one more thing, sir? Yeah, my last court hearing that I will be able to get a hold to her when y'all took my phone.
Excuse me?
At my last court hearing, y'all took my phone. Y'all told me I'll be able to get a hold to her. I'm not able to get.
Here's where things get spicy. The defendant challenges the judge, basically saying, "You just explained law school to her. How am I different?" The judge, clearly done with the back and forth, shuts it down fast. No more debate. No more legal classroom. Boom. Case set for examination. That's courtroom energy shifting in real time.